Welcome back to Herald Now. I'm Michael Morrah. The suitcase murder trial and the Loafers Lodge murder trial are two very different stories with one common thread: the defence of insanity. Simon Moore is a retired High Court judge and he's here to walk us through the insanity defence. So what constitutes insanity in the eyes of the law, Simon?
Well, it's probably easiest, Michael, to go back and look at how historically the defence developed. So way back in 1843, a case called McNaughton developed a set of rules called the McNaughton Rules, which have found their way into our Crimes Act, which is the code that covers all criminal offending. And some of the language in that section is reflective of the 1843. So in order to succeed in a defence of insanity, the first thing, which is really a bit of a departure from what happens in the criminal generally, is that it's for the defence to prove insanity. So the Crown has to prove most criminal cases beyond a reasonable doubt. But with insanity, it's incumbent on the defence to satisfy the jury on the balance of probabilities that a person is insane.
Okay, but surely not every person who is mentally unwell would meet the threshold of insanity. So what are the key ingredients to work this out, I guess? Is it a case that you have to have, say, a psychologist's assessment in the immediate aftermath of the crime to be successful, or?
That's a really good question, because as we know, there are lots of people in our community who suffer from various forms of mental illness, and they're not out committing crimes. What insanity requires is, first of all, a disease of the mind. Now, that's a legal expression, it's not a medical expression. You won't find that anywhere in any medical textbook or psychiatric book. That's the first point. A disease of the mind, generally speaking, is accepted to be one of the commonly understood organic mental illnesses, say schizophrenia. But as you point out, that's not enough on its own. The mental illness needs to be to such an extent that the person is incapable of understanding either the natural quality of the act or understanding that the act, that is the act which caused death, was morally wrong, having regard to the commonly accepted standards of right and wrong. And that's the kicker here. So you not only have to have a mental illness, but it has to be to such an extent that it's right.
So for example, just to assist our viewers and listeners this morning, if you are psychotic, for example, during the time that those crimes were carried out, I mean, just that essentially means that you have a completely different outlook on reality.
Exactly.
You don't know what's happening in reality. Is that right?
Pretty well. I think possibly one good example is the use of the expression morally wrong. So someone might know that what they're doing is legally wrong, but it has to be morally wrong. So that if, for example, they're having hallucinations, the divine intervention, for example, is directing them to do what they're doing. That, in their assessment, is morally justified, even though they know that after this they might end up being arrested. So that's the distinction.
Yeah, it's interesting because you've worked on cases, I guess, where people have known what they've been doing but have still been found not guilty by reason of insanity. Is that right?
Yes.
Yeah,
yes.
Right. And so what do you say to, I guess, victims or family members? Because I guess, and in the mind of the New Zealand public, obviously, it's often hard to understand, but I think it's important to spell it out. When you have a not guilty verdict, but the harm is still very obvious, right? And that, is there an issue there?
Well, there has been an issue there, and I know that victims of particularly homicide whose loved ones have been murdered, but where the defendant is found not guilty by reason of insanity, find it very difficult to rationalise that, because there's no doubt at all that their loved one's been murdered, but they're found not guilty. How do you rationalise that? So about 3 or 4 years ago, the law was changed, so that the verdict now is act proven but not guilty by reason of insanity.
Yes, that's a good point. It is quite a complex situation, but an important one for people to grasp and understand. I really appreciate your insights this morning. Simon Moore, retired High Court Judge, thanks so much for joining us.